Hello, everyone. I'm Kevin Gosztola, Shadowproof Managing Editor. I'm wrapping up coverage of the 8th day in Julian Assange's extradition trial. Flying solo today, my co-host, who has been walking me through reports, is dealing with a family emergency, nothing too serious, but I'm going to walk you through my coverage without his assistance. Usually he's kind of a guide to help us get through everything important, and I view what he does as extremely helpful. But nonetheless, I can still talk to you about the case, and I'll also give you all an opportunity while I am here and following the comments closely. If anyone has any questions for me, wants me to talk about any particular part of the extradition trial so far, I'm happy to answer those questions. So go ahead and drop it in the comments on YouTube, or if you're watching this on Periscope, however you're watching it, go ahead and leave it here. You might be on Facebook. You can do it there as well. So let's get into it. Wow. I'm going to work from what made sense, and then we'll get into what didn't make sense with the proceedings today, because that would be how I break it down. So we had John Sloboda, who's a professor, who was part of the Iraq Body Count Project. And the Iraq Body Count Project worked with WikiLeaks on the Iraq war logs releases, did very intense analysis of it. And with their work, they were able to uncover that 15,000 civilian deaths were previously unknown. So they were able to add to the official civilian casualty count 15,000 people that were in the U.S. military reports from Iraq, the Iraq war logs release. And he took the stand to testify about the steps that were taken to prepare the material, the way in which Julian Assange and WikiLeaks took great care to make sure that confidential human sources, the names of potentially vulnerable individuals, were redacted and removed from the documents. They used software. What they basically did is, although it might come off as somewhat xenophobic to some people here in the United States, they recognize that most of these names are not in English dictionaries. And so they set it so that anything not in an English dictionary would be removed from the Iraq war logs, which essentially meant that a lot of people's names from Iraq were automatically removed. And they actually over-redacted was Sloboda's testimony, that in fact there were some materials that had more redactions than were required to protect people. But that redaction did take into account something called jigsaw identification, which means if you have the name redacted, but you don't remove that person's occupation, or perhaps where they work, or maybe a location detail that would reveal their identity, then you run the risk of people being able to work backwards and put the pieces together and out that individual, even though you held back their name. And so the Iraq Body Count, in their work with these materials, made sure that they were protecting the people's names in these records. And Julian Assange was totally on board with it, was the testimony that we heard. The court was told that at no point did he object to the rigorous process being used to protect the people who may have been revealed. In fact, it was the media partners who had gone ahead and taken a small number of the war logs, performed their own redactions that were ready to go forward before WikiLeaks had been able to take great care with these materials and complete the redactions. And they were pushing for an earlier publication date. But as this redaction process took longer and longer, they were becoming impatient. And WikiLeaks said, we're not going to let the media organizations publish before we are done with the redactions of these war logs. And what this record set is one of the only records of these deaths that exist out there. The deaths documented in these war logs have never been corroborated in any other data set. So the prosecutors tried to find a way to get at Sloboda and show that Julian Assange was reckless with the material, but not really with the Iraq war logs. I mean, they did ask him if he was aware of two examples of documents in which I believe Julian Assange is charged with disclosing, two examples of individuals who may have been harmed. Sloboda had no recollection of those names being mistakenly left in the materials. But then they read statements that Julian Assange made about the Afghanistan war logs and how he responded to critics who believed names were left in that were endangering them, that had left them open to harm. And Sloboda had no recollection of these comments. In fact, in his own work with Julian Assange, he had never heard Julian Assange say anything that suggested he did not take protecting these people's names seriously. So ultimately, we had a fishing expedition by the prosecution in the morning that did not come up with much of anything. And as far as showing that Julian Assange didn't engage in responsible journalism with this organization, they tried to suggest that somehow maybe the Guardian and the WikiLeaks had these materials and they didn't do a good job of securing them, that maybe they went through the hands of people and can you really tell who had them? But there wasn't any evidence they were able to glean to prove that Julian Assange was reckless. And so that brings us to the afternoon. We had a witness who took the stand. His name is Kerry Shankman. He's a constitutional attorney. He's involved in work that he has been doing for the last 2 years to put together a book that is a study of the U.S. Espionage Act as it is applied in the United States. He looks at case law. It's very detailed analysis, a political analysis of the way it was used. In fact, while I have you and I'm doing it this way, I'm just going to take a moment to read an important section from his submitted testimony. So I'm going to look away a little bit here and read this. The Espionage Act of 1917, passed by Congress on June 15th, 1917, and further amended 11 months later, was expansive in scope. Despite the removal of the most egregious passages of the original bill, the act threatened First Amendment rights more than any federal statute passed in the previous century. Its full title is noteworthy: an act to punish acts of interference with foreign relations, the neutrality and the foreign commerce of the United States, to punish espionage, and better to enforce the criminal laws of the United States and for other purposes, end quote. Whilst the Espionage Act established harsh penalties for spying for a foreign enemy in wartime and in light of U.S. entry into the war, addressed such matters as U.S. control of arms shipments and its ports, the act also reflected the government's desire to control information and public opinion regarding the war effort. It embraced broad proscriptions against the possession and the transmission of information related to the national defense. And this information, by the way, is broad. It goes beyond simply classified information. It established severe penalties for criticism of the war, contained conspiracy provisions, and established a censorship system for the press. The original legislation was not demarcated as wartime emergency legislation. Key provisions would continue to apply in times of peace as well as war and remain in force a century after their enactment. And this is important. This is the context, the historical context in which this unprecedented case is being brought against Julian Assange. And Kerry has the expertise, having written this book that is yet to be released, but has already been peer-reviewed, as he said. And he talked about why this was unprecedented. There are no publishers that have ever been prosecuted under the Espionage Act. He mentioned 3 grand juries in which there were charges that were considered. They were considered against the Chicago Tribune, there's Amerasia, and then there's also the Pentagon Papers grand jury case investigation. And yes, as Jeremy is pointing out, the first 2,000 prosecutions of the Espionage Act were all political. It's something that Kerry said during his testimony. So thank you for bringing that up in the comments on YouTube. And so he outlined all of these sections, and I want to just say that these are the areas in which the prosecution could have asked Kerry any questions that they had today. The legislative history of the U.S. Espionage Act from its first enactment in 1917, the way it's applied to the publication of secrets under successive U.S. administrations. He could comment on the application of it in light of the U.S. extradition request for Mr. Assange in 2019. He could have commented on the history and application of the Computer Fraud and Abuse Act. He went ahead and wrote about the Computer Fraud and Abuse Act that Julian Assange is charged with allegedly violating. He could have commented on the critiques and analyses applied to the content and the application of either of these laws. So criticism and discussion of the way in which the U.S. courts have ruled or the way in which prosecutors bring these cases. And what did we get with the prosecutor this afternoon? Well, Claire Dobbin, who I believe this is the first witness that she has cross-examined in the extradition trial, had Kerry before her, and she first tried to disqualify him in the eyes of Judge Vanessa Baretzer by going at the fact that he worked for Michael Ratner, who was the president emeritus of the Center for Constitutional Rights when he was part of the WikiLeaks legal team. And Michael Ratner is unable to participate in this case. He can't give testimony. He can't take the stand. He probably would be doing something similar to what Kerry is doing. However, there's a problem. He's dead. He no longer is living because he died from cancer in 2016, tragically. And so this prosecutor insisted upon interrogating Kerry about statements and actions that Michael Ratner engaged in as a part of WikiLeaks' legal team when Kerry was only an associate. I hesitate to use this word, but perhaps we could see him as some kind of an apprentice who was learning the way to practice law. He was getting Michael Ratner was his mentor. He was learning what he needed to do to be able to work in his own capacity today and to give this testimony. And yet this prosecutor was taking the time to ask Kerry Shankman what was in the head of a man who is now dead and cannot qualify any of these statements and give us any better understanding. And I deeply miss Michael Ratner. I wish he could have provided testimony in this extradition trial. It would have been important to have him take the stand. But to use his associate to try and undermine statements that he made, or to try to suggest that these statements that he made previously were incorrect, is a waste of the court's time. We proceeded onward, and eventually we were veering into entirely hypothetical discussions of things that were written in rulings by the courts, in some cases that were, I suppose, somewhat relevant to this case. But everything the prosecutor was talking about was mostly abstract and had little to do with what is at stake in this case, had little to do with the submission in Kerry Shankman's testimony. And this went on and on, about an hour. And eventually we got to the end of the day, and we realized we were over time, the prosecutor did, and said she still had another hour of cross-examination for Kerry Shankman. And so we were going to take a break. But, in the run-up to that, Kerry was saying, I don't think this is a good use of the court's time. You're basically showing me things that are written down in this bundle of information that, by the way, was just provided to me when I took the witness stand. It should have been given to me far before this time so that I would have some knowledge about it and I could speak to you. So as a member of the press, I have to tell you, it was really frustrating to follow what the prosecution was trying to do, because the witness had no knowledge of what was being talked about related to Julian Assange. And I don't really know why I should waste any of my time putting this all together to do a report, because it didn't bear anything important for the prosecution. I mean, I don't even think you can call it a fishing expedition, because Kerry turned around and was essentially slapping the prosecutor in every which way because she was not handling this line of questioning appropriately. It had nothing to do with his submission to the court about the Espionage Act or the Computer Fraud and Abuse Act. And she was just trying to get him to look at lines in judicial rulings and answer yes or no to them. But you can't say yes or no. Let me give you an example. This issue of whether unauthorized access to a computer would be protected under the First Amendment was put to Kerry Shankman. Is that permitted under the First Amendment? Well, he said, and this is true, that in the courts, there is disagreement over what the words authorized and the words and unauthorized mean. So what does authorized mean? What does unauthorized mean? So you can't just say yes or no to that question. There are different interpretations of just a single word here. So why are you wasting our time, prosecutor? And exactly that. And so she couldn't get Kerry Shankman to give quick answers. She couldn't get movement in the right direction with this witness. She wasn't able to accomplish her goal as she was trying to do with this witness. And so at the end, she turns to the judge and she complains about Kerry Shankman to her. And magnificently, the judge said, I don't want to hear it. You've taken a long time. You've slowly tried to develop your questions with this witness. You take the consequences of your approach, was her response to Claire Dobbin. And I think that's the most appropriate thing that she could have said to that, because she was told repeatedly that the questions she was putting to Kerry were not related to his testimony, and that he would like to answer questions that relate to the case. And she was dancing around it, not getting to it, more focused on proving the fact that he was biased, trying to show that he's not really an expert by asking him questions about cases that he never claimed to be an expert on. And she got nowhere with this tactic, with this whole strategy with the witness, honestly. And it ended in this proceedings being over for today, and he's going to come back for another hour, and they'll have time overnight to regroup. But they really should get to asking questions that relate to their case. But I think it's a fundamental thing that we've come to understand about the U.S. prosecution of Julian Assange is that as it is charged, they cannot defend it. As it is charged, they do not like to talk about it. They are willfully misinterpreting their own case and trying to pretend like they did not charge Julian Assange in an unprecedented manner because they have to convince this judge to authorize extradition. So in effect, they are weakening their own case by acting like the case is not what it was as charged. I cannot tell you how many witnesses have had to point out what is truly in the indictment because they want people to pretend like Julian Assange was charged differently. So that does it for today. We have a witness tomorrow whose name I don't exactly recognize. Witnesses are moving. We have witnesses that are being scheduled and then they get shifted to other days. There's also a lot of back and forth going on around, I think, a dozen or so witnesses whose testimony has been agreed upon in order to bring our witness list that was 39 when we started down to a much lower number because the proceedings are far behind. We had the COVID scare last week. That was exactly a week ago. And then we've had technical difficulties that have delayed proceedings. And so let me get to a couple questions here as I wrap up. As I promised, I would take a few questions from you. And if you have anything you want me to slide in as we're wrapping, just let me know. But first, thank you to everyone for all of your support of my work. I have the donate link there if you think you can throw a buck or two my way to help keep this journalism going. I really appreciate your support. And then, of course, there's the dissenter.substack.com/subscribe if you would like to be getting the daily written reports that I put together every day. And so, what we have is, okay, Jeremy asked if there's a witness list somewhere for the defense and prosecution. My answer to that is there sort of was. I did a preview before this all started. I don't have the link handy off the top of my head, but if you go to Shadowproof or the Dissenter, you can find it. And I went through several of the witnesses that are expected to be called. Who we have not heard from yet are any of the doctors or psychiatrists that have treated Julian Assange. We haven't heard anyone who will speak, who has spoken about the UC Global espionage operation that was backed by U.S. intelligence against Julian while he was in the Ecuador embassy. We have not heard some other testimony relating to the way the releases were handled. We haven't heard testimony about the Guantanamo files. We're still expecting a journalist named Andy Worthington to testify, who has done tremendous work on these on Guantanamo over the last 15 years plus, I believe. So I hope that somewhat answers your question. And then I see a question here from Kyle, who says, if extradition's denied, does Assange go free at once? I do not know. I think that depends on what happens in the appeal court, because then the government would be able to make an application for him to remain in jail and have his bail denied. So the question of bail is something that can be litigated again, I believe, in a higher court. Do I know if Priti Patel had to sign off on a new extradition request, or are these proceedings under the old one? That I know, this new fresh extradition request that we are reviewing was not given some kind of stamp of approval by the UK government. It's my understanding that it is possible to keep submitting repeatedly newer extradition requests, but I do think that you're straying close to violating the treaty if it starts to veer from what the initial charges were. And certainly there was a deadline last year in June 2019 when they had to have all the material in for the courts on what they were going to charge Julian Assange with committing. The chances, what are the chances Assange gets extradited regardless of how the trial goes? Well, this extradition trial, it's my position that the judge is going to extradite Julian Assange unless she is given some reason to believe by the defense that she should not grant that extradition request put in by the U.S. government. So that is what we are seeing right now with all of these witnesses. The Assange legal team is working overtime, I think very close to 24 hours a day, trying to put forward evidence that will give Judge Vanessa Barretzer a reason to deny this extradition request. And I don't know if we're there yet. I'm not sure what it would be that she's going to end up seizing upon, but they're giving her several angles to justify not approving the extradition request. So I think that brings us to the end of the report for today. I see a note that he needs diplomatic recognition. That has been attempted. In fact, I mentioned that back in 2017, December 2017, they were about to try to get him out of the Ecuador embassy with his diplomatic passport to get to Ecuador on Christmas Day. However, they did not feel that it was going to be possible to succeed in doing, so they abandoned that plan. And then the U.S. government issued an international arrest warrant immediately after, because they likely were eavesdropping on Julian Assange through UC Global's spying equipment that was targeting Julian Assange. So I will end. And again, as people are noting, this judge has approved 96% of extraditions. Yeah, if you are a supporter of Assange, you're hoping he ends up in that 4%. And so we'll see what happens. And so thank you for following my reporting. Thanks for all the support. If you want to see my updates on any given day, you'll go to @Kgosztola, and I'm creating these threads of what happens on any given day of the proceedings. And these live updates that we do after court run anywhere from 15 minutes to a half hour. I took a little bit longer time today answering some questions from people who are tuning in to this live broadcast. But I could not do this without you. I have all of you out there that are watching and responding and engaging with my reporting, and I think that is tremendous. So I wish all of you well, and I'll be back tomorrow with day 9, with coverage of day 9 of Julian Assange's extradition trial.